bringing together voices in child and youth healthcare. This is CAFC Presents.
CAFC would like to thank the following member organizations for their generous support of our knowledge translation activities: the IWK Health Centre, the Children's Health Foundation of London, the McMaster Children's Hospital Foundation, the Children's Hospital of Eastern Ontario Research Institute, the Children's Hospital Foundation of Manitoba, the Montreal Children's Hospital Foundation, and the Holland Bloorview Children's Rehabilitation Hospital Foundation. We would also like to thank the following Keystone partners for their ongoing contributions that support all of CAFC's programs and activities.
And I'd also like to introduce myself. I'm Doug Maynard. I'm the Associate Director at CAFC, the Canadian Association of Pediatric Health Centres. And our webinar today is titled Going Rogue, How a Canadian Children's Hospital Challenged Gene Patents. So it's going to be a very interesting story, a little different than our typical presentations, but I think it's going to be a great presentation today. I'd also like to mention the CAFC annual conference, this year being held in Halifax, Nova Scotia. Registration is now open, the preliminary program, lots of other information is up on the website at conference.cafc.org, so check that out, and hopefully we'll get to meet some of our audience in person in Halifax if you're able to join us there. All right, so as I mentioned, we do have a very interesting presentation today coming from one of our CAFC members and one of our KT partners, as you saw at the opening credits there, the Children's Hospital of Eastern Ontario Research Institute, and we also have people from the Children's Hospital as well, so this is a partnership from the folks from the Research Institute and from the Children's Hospital of Eastern Ontario. This presentation is definitely a bit different than our usual. This is about, you're not going to hear toolkits and clinical resources today. You're going to hear about a children's hospital taking a risk, taking a leadership role in an important advocacy issue, taking a stand that has benefited every hospital and healthcare researcher in Canada. So it's going to be a very interesting tale, and I think everyone's going to take something beneficial away from today. So without any further ado, we're going to introduce today's panel. First up, we're going to be hearing from Dr. Julie Richer, who's a clinical medical geneticist at the Children's Hospital of Eastern Ontario, and she's also an assistant professor at the University of Ottawa. Her clinical practice primarily consists of the care of patients with underlying connective tissue dysplasias, including patients with familial thoracic aneurysms. And following Dr. Richer, we'll hear from Dr. Olga Jarinova, who's a molecular geneticist in the Genetics Diagnostic Laboratory at CHEO, and she's also an assistant professor in the Department of Pathology and Laboratory Medicine at the University of Ottawa. Dr. Jarinova has been instrumental in expanding cardiovascular genetic testing services and introducing next-generation sequencing at CHEO's Genetics Diagnostic Laboratory. And then following Dr. Jarinova, we'll hear from Dr. Gail Graham, who is a clinical geneticist at CHEO and has been the chief of the CHEO Department of Genetics and the Eastern Ontario Regional Genetics Program since 2011. And finally joining them is Nathaniel Lipkus, who's a partner in Osler's Toronto office, Osler is an intellectual property litigator. Nathaniel is an intellectual property litigator. His practice focuses on contentious legal issues confronting innovation-intensive industries with an emphasis on patent and regulatory issues facing pharmaceutical and biotechnology companies. And Nathaniel was the co-lead counsel for CHEO's Gene Patent Challenge. So without any further ado, it's my pleasure to hand the virtual podium over to Dr. Richer.
So thank you very much for a nice introduction. I was asked to give you a little bit of background on why we launched this endeavor. So all of this goes back quite a few years ago when the CCMG, the Canadian College of Medical Geneticists, was asked to update their statement on gene patents, and we did so. And came up with a publication in 2012, which was published in Clinical Genetics, in which our organization stated that we basically did not think that a discovery could be patented. So the first draft was created by the Ethics and Public Policy Committee. It then went to the board of the CCMG. It was circulated to the entire membership and then published in 2012. So in 2012, we were already close to 2 years in that endeavor. And the premise was that DNA and RNA are products of nature, and that while DNA sequences may be discovered by a human being, we humans did not invent it. And if I look at this scenery, I can discover it, I can find it first, but I sure did not invent it. And the same goes for our DNA, regardless of how much I would like to own this scenery. And when we look at what makes discovery of new genes possible, it's really the result of an impressive collaboration, not only between researchers and clinicians, but patients are key partners in that endeavor, both contributing their biological samples and time, but also through public funding. So the whole Canadian population actually actively contributes to the discoveries we make. And if we look at public investment in enabling discoveries, if you look at health knowledge, there is quite a bit of money in CIHR, millions of dollars that are invested each year in furthering our medical knowledge, including our genomic medical knowledge. And patients come in, they give their blood, it's uncomfortable, they give their time, they even pay for their own parking. And while this may not be the reality of the majority of the people on this panel and listening to this panel, for some of my patients, paying for parking at the hospital means that they do not go to the movie or to the restaurant that weekend because it is an important part of their resources. And still people do it. And most people who contribute either to advance medicine or to improve the life of others. Very few people do it for their own primary benefit. They do it out of altruistic concerns. And the relationship that I have with my patient and that every physician is supposed to have with their patient as a result of the Hippocratic Oath is a fiduciary relationship. And what that means, the definition is that the trust of a person with inferior power, that another person who has assumed superior power and responsibility will exercise that power for his or her good and only for his or her own good and his best interest. This means that I must protect the best interest of my patient. It is not optional. So what's our part of the deal when we ask our patients to contribute to medical research? Well, our part of the deal is to protect their best interest. That means to advocate for our patients to have access to the best diagnostic technology, which includes optimal interpretation of clinical investigations. My part of the deal is also to respect their autonomy and their wishes. So most patients want to have access to the best care possible, and that means to protect access to genomic technology for the Canadian population and deliver cost-effective health care. So what's genomic technology? Well, we have approximately 22,000 pairs of genes in our body. We, as a scientific community, know what about 5,000 of them do. And when we look at a gene, we tend to believe that a spelling mistake or mutation in a known gene is automatically disease-causing. Well, that's really not the case. When we go for a walk on the street, we all look different and people can recognize us. That's because there's actually small differences in our DNA. And interpreting which ones of those differences actually cause disease and which ones just make us recognizable on the street is really the challenge that we face in genetics, and Dr. Jarinova will talk more about this later. And predictably, over time, as we're building bigger and bigger panel and looking at more genes, sometimes we're finding out that what we thought we knew, we were actually wrong. So in terms of cost-effective healthcare, to put this in perspective, the UGOR project in the 1990s cost hundreds of millions of dollars to sequence the first version of the human genome, and it took over 10 years. Now, sequencing a genome can be done in less than a week. And if you just look at the reagent, you can do it for about $1,000. And commercial laboratories are offering it with some interpretation for both the child and two parents at the same time for under $5,000 US. So we've come a very, very long way to where we were before. And it allows us to sequence lots of genes for cheaper than just one previously. But we also spend a lot of money on healthcare. And while we're way behind the US and Canada, we're still up there in terms of industrialized nation. And if you look at the distribution of government expenses, healthcare compared to other areas of expenses, healthcare is already a really big piece of the pie. So there's not that much room to grow. So we must spend our resources wisely. Luckily for us, as I just mentioned, the new technology opened new possibilities. This is the pace of gene discovery over the past 30 years or so. It has just exploded with those new technology. And what genomic medicine allows us to do is to find a diagnosis more often, have a better idea of the prognosis and how to best take care of these patients. And we've gone from a land where we used to think of one disease and test for that one gene to panels where genes are part of families, where we test for the whole family of gene all at the same time, or even to bigger and bigger panel like a clinome, which is the 5,000 genes, which we kind of know what they do, to an exome or a whole genome, which is really looking at all of our DNA. And now we're in an era where we even have clinical guidelines of how to use this technology. This is another statement from CCMG from just last year. So really, if you're thinking of building a panel, the advantage of it is to put all of the genes that are in your differential diagnosis and test them at the same time. The problem that patent pose is that if you own one gene that should be in that panel, does that you should own the whole panel and that nobody else can do the panel? Or does it mean that other people must go literally fishing with a fishing net which is full of holes because you've left important genes off your panel to avoid patented genes, in which case you're really missing out on the cost saving that this technology can afford you, both in terms of money to run the tests and then interpretation time, time of the patient, time of the clinician, all resources that we do not have enough to spare. So how would those patents threaten the care we deliver in the clinic? Well, they could diminish or abolish competition for single gene testing by removing incentives to improve service if you have a monopoly, for example. They could greatly limit competition for panel testing, and they could also limit the ability of a laboratory to report on clinically significant incidental finding derived from whole exome or genome sequencing. So if you sequence all of the genes in the body, sometimes you may stumble upon something that is unrelated to why the patient came to you, but that is still really important to their health care. And if that gene is patented, does it mean you cannot report it, despite the fact that it may very well go against the best interest of your patient? So let's think of two children who undergo that whole exome sequencing. And one child is found to have a mutation in a gene called ACTA2, on which there is no patent, and that gene causes thoracic aneurysm, so enlargement of the blood vessel leaving the heart to a point where it can rupture, and if it ruptures, you have a 50% chance of dying, versus it can be repaired on time if somebody knows about it. This gene is not patented. It is disclosed to the family, and the father who happened to carry this stays because he has an elective surgery. Then imagine that another child has a disease causing in a gene called KCNE1, which is one of the genes responsible for long QT syndrome, a cardiac arrhythmia where the heart rhythm is off and the first symptom can be sudden death. The parents of this child are also at risk for this, and so is the child. But there's a patent on that gene. Would you feel comfortable not disclosing that risk while this whole family may benefit from care from cardiology? So what's long QT? It's a heart rhythm disorder where the heart beats fast and it beats in an uncoordinated fashion. It can arise from mutation in one of several genes, and it is autosomal dominant, meaning that there's a 50-50% chance of transmitting the mutation to his or her offspring for somebody who does have the mutation. And if it is diagnosed, it is actually treatable. So if we come back to our initial question, a gene sequence is a naturally occurring substance. It's not an invention. The technology with which we assess such sequence has changed dramatically since the discovery of most of those patented genes, and the interpretation of such sequence is still a work in progress. We're still learning more about what different variations in these genes mean. Moreover, the discovery of such sequences was made possible by publicly funded research and patients who altruistically contributed their time and biological samples. So is it fair then to ask our patients and the whole Canadian population to altruistically contribute to research and then let patent on genes prevent our population and our patients from reaping the maximum benefits of the discoveries they rendered possible without putting up a fight? Well, we didn't think so, and that's why you'll hear more. Olga?
All right, thank you, Julie. Good morning, everyone. It's my pleasure to be here today. And in my part of this webinar, I will be talking about exciting new molecular technologies, next-generation sequencing. I'll talk about precision medicine, the role of diagnostic laboratories in clinical diagnostic testing, and at the end, I will discuss how gene patents can stand in the way of progress of molecular diagnostic laboratories. So before I begin, I would like to define some of the basic terms I will be using through my slides. Gene is a sequence of nucleotides along a DNA strand that encodes a specific functional product, such as protein. Genetic diagnostic testing refers to identification of genetic changes or variants in genes associated with a specific disease. As Dr. Richer mentioned, we are not looking for variants that are associated with different features, phenotypic features. We're really looking in this context for variants that at least partially explain the disease. And precision medicine refers to tailoring of person's medical management to this individual's specific characteristics, such as genetic variants. And you can, of course, see how precision medicine and genetic diagnostic testing intersect here. Molecular technology that was considered as a gold standard until probably recently is a sequencing technology. Sequencing, in essence, is a process of establishing the exact order of nucleotides in a DNA strand. And although this slide may look a little busy, I would like to point out two basic principles of Sanger sequencing. And really that is amplification, of what it means that we focus on a target sequence, on a target of interest, and amplify this region many, many times. And then at the second step, what we do have is sequencing. That's an actual identification of order of nucleotides one by one based on fluorescent technology. Essentially, that's all it is. And if I can just mention, there is a bit of an echo that is happening. I'm not sure why that is. If it can be adjusted, that's just a note to the moderators. Okay. And how next-generation sequencing is different, it's also involved two main steps, amplification and sequencing. So this part hasn't changed. What has changed is that it allows for what we call sample multiplexing. What it means is that samples from different patients can be sequenced simultaneously at the same time. And in the second step, sequencing step, all these different samples can be sequenced at the same time again, so not only amplified, by sequence at the same time in thousands and thousands of copies. So what that means is that next-generation sequencing technology clearly translates into significant cost savings and also time savings. That is essential. If you look at the progression of how price or cost of sequencing has decreased over time, many of you remember or heard of Human Genome Project. Human Genome Project took a decade to complete and more than $3 billion, a significant amount of money. In 2007, with Advent, that's where next generation sequencing technology come into play. You can see that there is a significant drop in cost of sequencing. So much so that, as Dr. Vischer mentioned, right now it takes only $1,000 in reagents to sequence the entire human genome, so all the genes and everything in between combined. And of course, what it means is that next generation sequencing technology is very quickly integrates in various branches of medicine, be that carrier screening, pre-implantation genetic screening, non-invasive prenatal testing, or the focus of our laboratory, inherited disease testing. And like many other laboratories, we definitely went ahead and implemented next-generation sequencing and made it part of our regular operations. What you see here is our different tests that we provide in our molecular genomics section of genetic diagnostic laboratory. And while some of them are not next-generation sequencing based tests, they are on the right. All the tests on the left, so more than 50 genes, we sequence using next-generation based technology. And these are an examples of two, probably the most comprehensive panels that we recently added to our menu. One of them is extended cardiomyopathy gene panels. This panel consists of 46 genes associated with cardiomyopathy, and depending on the reason for referral, depending on clinical phenotype, we would sequence all or just a subset of these genes. And the other panel is thoracic aortic aneurysm and dissection gene panel, so 13 genes in total. And as you can imagine, identification of disease-causing variant in a patient can have a very beneficial impact on this patient management, and particularly on management of this individual's family members, if they're found to be at risk for these disorders. And this slide to show how the structure of CHEO departments of genetics, and I thought I would show this slide to demonstrate how medical genetics and clinical laboratory scientists overlap. So we have a genetics clinic, and both Dr. Graham and Dr. Vischer are medical geneticists. They're practicing in various clinical genetics discipline. As it was mentioned before, for example, Dr. Vischer's specialty is connective tissue disorders and cardiogenetics. So as you can see at the bottom right corner. Genetics Laboratory are also part of the Department of Genetics and Eastern Ontario Regional Genetics Program. We have laboratory scientists, technologists, technicians, genetic counselors, and genomic specialists, and two sections of the laboratory, cytogenomics and molecular genomics. And I am here representing molecular genomics. So what I would like to briefly mention at the next part of my presentation slide is actually define the role of genetics diagnostic laboratory in patient care. In many ways, we are similar to other type of biochemical, to other type of diagnostic laboratories, such as biochemical laboratory, for example. But there are some differences. So the general laboratory workflow is very similar. First of all, what usually happens is the referring provider meets with the patient, arranges for blood draw and for a test to be requested, sent to a specific laboratory. Then the sample arrives. We process this sample using instruments in our laboratories, and while they are very sophisticated and at times quite expensive instruments, they are, in essence, instruments, just like in any other laboratory. It includes DNA automatic extractor, as you can see here, Kaya Symphony, and other type of extractors. Then analytical portion of the workflow begins, and again it's involved instruments, next generation sequencing instruments, for example, as you can see at the bottom left. And this essentially what happens is that DNA sequencing is being read and a lot of genomics data is produced. What's different about genetics diagnostic laboratory is post-analytical part of laboratory workflow. In some analysis, for instance, when we're dealing with automated analyzer for whole cell blood count, there is a data that is automatically processed, and there are specific values that are assigned. So interpretation is not as intensive, or may not be as intensive as what we deal with. And the reason for that is because, of course, not every single genetic change is defined, and often we don't know what it means. So it's similar. Exploring a significance of genetic data could be compared with looking at pathology slide, for example. Although many times you can look at the slide and know exactly what's going on, in many cases you don't, and you rely on a professional judgment, and a lot of exploration and opinion goes into play. And this element of intricacies of variant interpretation receive a lot of attention in the literature. That's for instance, there was an article in Genome Research, and one of the bloggers, Eric Celeste, stated something that I thought was particularly insightful. He said, in regards to variant genetics interpretation, assumptions are dangerous things to make, and like all dangerous things to make, bombs, for instance, or strawberry shortcake, if you make even the tiniest mistake, you can find yourself in trouble. And that's, I think it's an important message, regardless of the context, but particularly relevant when it comes to variant interpretation. And here is an example of what could happen. We don't know if it did happen. That's just a lawsuit that was launched by a family member of an individual that unfortunately passed away. And what the mother claimed is that laboratory did not interpret a variant significance properly. Laboratory interpreted this variant as a variant of uncertain significance when it is claimed that the data existed at the time to suggest that interpretation should have been different. And what we do in our laboratory, we do the best we can to define if a variant we see is pathogenic or disease-causing. Is that a variant responsible for patient's disease, or it is benign or neutral variation that doesn't have anything to do with the question asked? And we have a variety of computational data that we rely on. We screen population data sets, we look through the literature, we look through various publications, and we have a computational matrix in a way when we put this all together to produce a meaningful interpretation. But that being said, many times, no matter what we do, we're still unable to clearly define if a genetic change we see is benign or is it pathogenic. And then the report states that a variant of uncertain significance was identified. And as you can see on the graph here, the more genes we sequence, the more variants of uncertain significance we find. So the more comprehensive our panels are, the more variants of uncertain significance are there. And to make things even more interesting is not only it's tricky to interpret variant based, because we have to look at every single piece of evidence that is available to date. Even when we do it with absolute precision based on the current scientific knowledge, this knowledge may change over time. And variant that is now correctly classified as a variant of uncertain significance tomorrow can become likely pathogenic because the new evidence become clear, for instance. And that's an example of this actually happening in real life. That slide was provided to me by Dr. Heidi Rehm, who is a director at Partners Healthcare. And the story here is that prenatal setting was tested based on ultrasound finding that may suggest Noonan syndrome. And at the time, laboratory identified a variant that was interpreted as pathogenic. Unfortunately, years later, it became apparent that this interpretation was not accurate. And this is because we now know, Dr. Ream's laboratory didn't at the time, but we now know, and it is in public databases, that this variant is particularly frequent in Ashkenazi Jewish population. And of course, parents in this case were of this ethnicity. And therefore, interpretation has changed given this new data, and this variant is now classified as benign. Unfortunately for this family, this pregnancy was terminated. So what it means is not only we have to do a lot of research and look at the literature and really put a lot of our thoughts into interpretation, we need to do it all over again after some time has passed because interpretation can change. And now currently our interpretation workflow is such that if we see a variant more than in 1 year or more than that in a different individual, we reinterpret significance of this variant to make sure that no important information becomes available that would change classification of this variant. And that's an example of our report in a very simplified way. We defined what is a result, what our molecular genetic result is. In this case, we carried out pan-cardiomyopathy panel. We'll state what is the variant, what is the nomenclature, what is our classification. And we also provide all the information to referring providers to allow him or her to make the most meaningful decision with regards to this patient's care. We state what the variant we identified. We state what is the predicted cause. In this case, this variant is predicted to cause a frame shift, which is a very severe genetics lesion. This variant has not been reported in this case in any articles and has not been deposited in the databases where other clinical diagnostic laboratories share the data. If it did happen, we'll summarize all the evidence. And we also look at the population databases, so all the databases representing presumed healthy individuals to see if it was seen there. If the variant is seen at a very low frequency, as the case here, this will further make it more likely that this variant is pathogenic. Based on all this evidence, we'll then follow CCMG guidelines and categorize this variant appropriately. In this case, this variant was categorized by our laboratory as likely pathogenic. And we do think that it has contributed to the development of cardiomyopathy in this individual. So this new tests that we have added to our menu less than a year ago received significant attention in local media, and this is because in fact we are the only laboratory in Ontario designated by the Ministry of Health to provide the testing for cardiomyopathy, for example. And our testing volumes have more than doubled over the course of the year. And finally, I would like to conclude by essentially demonstrating how gene patents can stand in the way of the progress of our laboratory with regards to further expansion of cardiogenetic services. So that's an example of the panel. It's a kit that we use, produced by a company called Illumina, and that captures, allows us to capture and sequence all these genes in relation with cardiac manifestations. And we currently using this panel for our thoracic aortic aneurysm and dissection test, but prior to this court challenge, we couldn't look at genes, at these 5 genes that are in black. And this is because they had patents on them. We couldn't explore the possibility of including them or adding them to our test menu. Now we have some certainty, we can now clearly explore this possibility and move forward. So I think with that, I will thank you for your attention and ask Gail to take over.
So having already understanding the theory of why we oppose gene patents and how it was that they became important to our clinical care, what I'd like to focus on is really perhaps the most obvious question in retrospect that many of you might have wondered about, and that is why CHEO? And the answer really is partly serendipity, partly good timing, partly, I would say, some idealism and naivety, and partly the environment in which we found ourselves. And I'll discuss all of those issues as I move through my short part of this presentation. So Olga's already told you a little bit about next generation sequencing and cardiogenetic testing. Although it's true that more and more genes are being discovered and that the cost of individual gene testing has come down dramatically with next generation sequencing, at the same time, the Ontario Ministry of Health and Long-Term Care was recognizing that the cumulative cost of out-of-country genetic testing for Ontario patients was increasing dramatically as these gene discoveries prompted clinicians like myself and Dr. Richer to be ordering genetic tests from U.S. laboratories that weren't available within the province. And so the test cost went from $1.5 million in 2004-2005 to about $20 million in 2011-2012, and now is somewhere between 30 and 35 million. So it really is an exponential rise in the amount of money being spent on out-of-province testing. And so logically, the Ministry of Health called for proposals from laboratories within the province to repatriate certain genetic tests, and among the most common and the most costly were the cardiac genetic tests. And so CHEO was successful in our application to provide province-wide testing for 4 cardiogenetic conditions initially. One of them was dropped because there was insufficient evidence for clinical utility, and we were supposed to have a contract to offer testing for the other 3. But long QT was actually withdrawn by the Ministry of Health before the contract was signed, before the announcement was made, and that was specifically due to a concern about existing patents, and the Ministry of Health had been made aware of those patents by the patent holders. So really we saw that patents were had the potential to greatly interfere in this patriation or repatriation process and to significantly increase the cost of healthcare in this area, and also to interfere in our capacity development. So this really is the serendipity part of our story. In the summer of 2012, through happy circumstance, we became aware of the interest of Richard Gold, who's pictured on the left of this slide, in this issue from an academic standpoint. Richard is a law professor at McGill University who specializes in patents in the biotechnology field. And he was working with a Canadian law firm, Gilbert's LLP, in Toronto. And the two other photographs you see on this slide are of Nathaniel Lipkus, who will speak after me, and Sana Halwani, who was at the time his colleague at Gilbert's, who were both very involved in this project. They were interested in commencing a Canadian test case on human gene patents, the goal being to clarify the law in this area in Canada, which had never been done before. And Gilbert's was willing to do this on a pro bono basis. So given the normal cost of patent litigation, this was an extremely generous gesture. Richard Gold had put together a research team, and they were applying for Genome Canada funding through a personalized medicine call, and they had been successful at the letter of intent stage to put together the social science evidence needed to inform the court about this issue. And so we knew that there would be experts willing to testify on a pro bono basis as well. And it was really this happy circumstance that that allowed us to even contemplate taking this major move. And so when we first asked ourselves the question, does CHEO want to be a plaintiff in a lawsuit against patenting of genes, there was an immediate, you bet we do kind of reaction. For all of the reasons that Dr. Richer has outlined, we just didn't think that this was right or fair. We thought it was morally reprehensible, and we thought that challenging this was the right thing to do for our patients and families. And so where great timing came into this story is really that in January of 2013, there was another call for applications, expressions of interest from laboratories in the province for further test patriation. And in that particular call for expressions of interest, the ministry explicitly directed labs that were interested to include in their application their rationale of how they were going to deal with patents. And so essentially the ministry put this issue in the laps of the labs that wanted to do the testing. And so at this point, I was only months into being officially the chief of the Department of Genetics at CHEO, although I had had a bit of experience in the acting role. I think this is also where naivety comes in, that this just struck me as a unique opportunity. And I know that seizing opportunity isn't one of my strong suits. In fact, like many people, I think I tend to find it hard to challenge the status quo. So it's hard for me to put into words why exactly I thought this was a great thing to do. But I did feel quite idealistic about it. And I know I was also very much influenced by the people around me. And so thinking back on this time, you know, what I'd say about this slide is that if the CHEO Department of Genetics had been a country, this is how we felt about it. We were all about sort of, yes, we can do this. And then, of course, there was the sober second thought, can we do this and how do we do this? And that's when our environment started playing a really big role. And so I've alluded to serendipity, to good timing, to idealism, but really this is where I guess idealism met environment. So we had two things that in retrospect turned out to be critical to the project, and one of them was a great vice president, and that was Susan Richardson, who has moved on to other things, but at the time she was our vice president, we had a great relationship with her. And I give her a lot of credit because she immediately saw the principle behind this, and she was all over it. She was enthusiastic, and she said, you know, I'm with you on this, and let me help you, let me show you the way, basically. And so it wasn't just Susan that was key to our success, although her support and guidance certainly paved the way for our presentation to the executive team at CHEO. I would say as a relatively new leader that this presentation was for me initially the most daunting, although it turned out that there were many more larger and arguably more intimidating audiences that we had to present to after this. We just didn't realize that at the time. I had worked very closely with Susan Richardson, who I already knew was supportive, and I was familiar with the medical leaders on our executive team, such as the Chief of Staff, but really I'd had limited contact with many of the other members of the executive team. We were only one of many items on the agenda of their meeting that day, and I knew that the presentation had to be succinct but also compelling. Our genetics team and our director, Gabrielle Metler, were there, and so I felt very supportive, and I just spoke from the heart. And I still remember our CFO, Nick Flacolius, simply saying that he thought this was a wonderful idea and exactly what a children's hospital should be doing, which just blew me out of the water because most people wouldn't think that way. So I think the environment we were in, the people we were working with, was a big part of the success of this initiative. The debate took place after we left the room, of course, but we learned shortly after that that the executive team was on board, and that was the beginning of a journey, basically. We had cleared what we didn't know then was the first of many hurdles, and so for a brief moment we thought, wow, we're just the Department of Awesome, this is great. And then and then we recognized that the hard work was only just starting, because we realized the next step required a completely different approach, and the next step, of course, was our Board of Trustees. And we learned a lot about how good our Board of Trustees really are, how savvy they are, how seriously they take their responsibility, which is protecting the interests of the hospital. They did that extremely well, and I left this very lengthy process with a lot of respect for these individuals. So what we had to convince our Board of Trustees and their various subcommittees of was that we were the right people to do this, first of all. So to file a suit, not a suite, as it says in the slide there needs to have been real damages incurred, and we had been actively prevented from doing a long QT test that we would otherwise have been approved to do. So that made us a good candidate. We happened to have a coalescence of expertise that was perfectly suited to this task. So Dr. Richer was the first author on the CCMG patent position statement that she mentioned. The molecular geneticists, including Dr. Jarinova, had expertise in cardiogenetic test interpretation. We have a researcher, Dr. Kim Boycott, here, who has in next generation whole exome sequencing and has led a Canada-wide consortium that's been the most successful gene discovery effort in history. And I was about to take on the presidency of the Canadian College of Medical Geneticists. And I mean, realistically, we knew that we wouldn't have been the only candidate, the only hospital that could have done this. But in the end, we turned out to be the best candidate, I think, partly because we didn't have existing patents or hold similar patents. And even just finding that out was an exercise in itself. So obviously, in all of our presentations to the Board of Trustees and their subcommittees, we had to talk about what risks this would incur to CHEO and how we would mitigate them. And so we talked about how lucky we were to have a crack pro bono legal team. We talked about the way Nathaniel came up with I don't know how many different presentations to talk about the way in which litigation can proceed and the points at which CHEO could extricate itself throughout the litigation. We talked about the pro bono experts. We had, quite frankly, no idea of the workload impact when we started out. We were fueled by idealism, and so we just said, we'll just absorb this work because we believe in this principle. We talked about what if the patent holders react in a very adverse way would we still be able to get this testing for our patients? Because at the time we were ordering it from a U.S. laboratory. We worked around that, and we talked about, the biggest potential risk to CHEO as plaintiff is that plaintiffs can be made to pay a proportion of the defendant's legal fees if they are unsuccessful in the litigation. And that was obviously a huge concern for our Board of Trustees. So this is where I say this is the time in the story where Obama met Putin, basically, in terms of, there being some resistance, or at least some skepticism, shall we say, appropriately. So those of you who have political sensitivities will have to forgive me, but this is mostly what our Board of Trustees worried about. But we kept calm and carried on. And we continued to explore risk mitigation strategies. So we knew that using CHEO operating funds was obviously completely out of the question. Those are public dollars. And our lawyers came up with a strategy that Nathaniel can speak much more with much more authority and eloquence on than I can, but it's called a no-cost motion. And it's an unusual strategy and not one that's often used, but it seeks a declaration from the court that costs will not be awarded if the plaintiff is acting on behalf of the public interest. We talked about our opportunities to abandon the case, often on a without cost basis. We talked about whether we could raise money from supportive foundations, and we also solicited the advice of outside counsel to represent CHEO, to give us an opinion that represented CHEO. So some of the things that influenced what I would call our circuitous journey through the land of Board of Trustees subcommittees were, what kind of impact would this have on our hospital's brand, on fundraising, on recruiting, on research grants, etc. So this turned out to be a far more complicated and thoughtful endeavor than we would have ever initially imagined. So this is basically a summary of our journey. It took more than a year, and for each of these presentations, there were teleconferences, there were often in-person meetings, there were emails and emails and more emails, there were briefing notes, and there were PowerPoints put together. And so we were basically sent from one committee to the next to address various issues as they came up. And it wasn't really until August of 2014 when our CEO and myself and Dr. Boycott, our researcher, met with Alan Rock, who was the president of the University of Ottawa, and Mona Niemer, our VP of Research, to actually solicit their approval or agreement that we could go ahead and do this. And you can imagine that was no mean feat, in the sense that universities rely on patents to protect intellectual property. So it was after that final meeting in August of 2014 that we finally knew that we were going to be able to go ahead. After that came additional time in the form of informing our own group about what was happening and doing media training. And one of the challenges of all of this is that everything from summer of 2012 up to summer of 2014 had to be done in the cone of silence. So our lawyers were pretty unequivocal about this, that if our plan to become a plaintiff in this litigation, the fact that there would be litigation, was leaked, then the defendants would have an advantage. So it was turned out to be an extremely time-consuming process that we had to do very quietly. So leading up to our launch day in the fall of 2014 in November, we had the help of one of our Board of Trustees, Jim Armour, who was a key player in Summa Strategies, and they were used to preparing people for media interactions, and we really appreciated that he offered his help on a pro bono basis too. And so we had some media prep with his team, and then we went on to do some advanced phone interviews with various members of the media and a video pre-taping with CTV. That was also a challenge because it was done 2 weeks before the launch day in our laboratory, and none of our staff in our laboratory knew what was going on at that time. So launch day was a whirlwind of activity. We had a technical briefing presentation for the media, followed by the press conference, TV and radio interviews, and we were all kept very busy that day. And at one point, Dr. Riche and I were doing radio interviews every 10 minutes as CBC moved across the country from east to west, I think it was. So we were really, really pleased with the attention we got, but we would have never had that much attention without the assistance of Ann Fuller, who's our VP Communications, and our team, our communications team. And so they played a huge role in terms of publicizing this initiative. There were also huge roles played by my other colleagues. So our director, Gabrielle Metler, was also fully immersed in the meetings and emails and written work and teleconferences, and she was covering for an absent colleague for part of that time. Dr. Riche and Dr. Jarinova were equally taxed in all of this. And so really this ended up being successful because of a whole lot of people and because they were passionate and talented. So this is an example of some of the coverage that arose from our launch day. This one happens to be CBC. This is a National Post article. There was very good coverage, and we were very surprised, in fact, that the defendants did not respond at all to the coverage in the media. They definitely were taken by surprise and probably didn't want to respond to a children's hospital that was promoting a public health issue. So I just wanted to point out that these are some of the key people involved. Christina Honeywell is in the second panel, Dr. Riche in the third panel to the right, and Dr. Jarinova in the final panel. And so with that, knowing that we're pressed for time, I'd like to turn the electronic podium over to Nathaniel Lipkus, who is really the key player in all of this. He now works for Osler Law Firm.
Thank you, Gail. I love hearing Gail tell that story. It is so easy in hindsight to think that CHEO's decision to participate in this case was obvious for all the points of principle that were raised earlier. Hopefully, after listening to Gail's presentation, that you understand that there is a process here, and it's very easy to just not do it. And having gone through the process of speaking to many who do care deeply about this issue, I'm of the view that what CHEO did to take leadership on this issue is exceptional, in the sense that if CHEO hadn't done it, it wouldn't have happened. And because not just Gail, but most people who have a lot on their plate, it's very easy to just be comfortable with the status quo. It's safe, and it's easy to just not rock the boat. And here we were trying to launch a pro bono gene patent case with complex issues of law. Lots of strong opinions, anxiety, policy considerations, and it would have been easy to just not do it. And so it took us several years, and after some efforts have been taken in the United States and Australia, we thought, well, maybe in Canada people might start to pay attention. And so we actually started talking to people in 2011, even before dealing with Richard Gold, who had been championing this issue. And what we found was not just hospitals or laboratories, but also patient groups and others were nervous. They did not want to be out front on this issue. They agreed in principle that genes shouldn't be patented and that there was an impact on what they were doing, but they didn't want to be the public face of it. And as was just mentioned, there were other groups that were that would have been interested in participating, but they were either nervous about their own patents, or they were nervous that they had already run genetic tests that may have been seen as a patent infringement. And it was just so easy to be focused on the risk and not the potential impact. So I have this slide, it says that, and it's two guys, they say there's a thin line between thinking outside the box and a caffeine-induced wacko idea. And I think it's very easy for when you're thinking through all the eventualities to fall on the other side of the line. I'm not saying that CHEO was crazy. In fact, and going to the next slide, there was a lot of support from other organizations. I think that there were barriers in those other organizations, and I saw them firsthand, that prevented this from actually going ahead. And one is a communication barrier within the organization. In CHEO, as we heard, there was a very healthy and direct line of communication between genetics doing what they were doing and the general operations of the hospital doing what they were doing. And in contrast to other institutions where it seemed where the genetics team, which agreed with what we were trying to do, was very strong-minded but also siloed. Another factor was participatory leadership. It wasn't in CHEO compared to other groups, although there's of course an organizational structure. It was quite clear that leadership within the hospital, based in principle that the hospital subscribed to, could make its way to the top. And although it may take time, one of the things that VP that we heard about, Susan Richardson, preached was patience and persistence. And that's what we exercised, and we were rewarded for it. And support of leadership still involved a lot of diligence, but not with a view to squashing the enthusiasm, but rather trying to be responsible in how we did what we were doing. And I did not feel as though I was facing off with Putin, although if I was, then it's then I'm glad that we were able to get it through. The board of trustees is made up of a lot of successful people with a lot of perspectives. But what was unique about the quality of conversation at the board level was it was based in principle and in pragmatism, and the quality of the conversation was very high, even among people who did not understand patent law. They were trying to figure out, are we best serving the public interest? Is it responsible for the hospital to act? And making decisions for the right reasons. And so based on putting all that together, the passion, the principle, the prudence, I couldn't have dreamed of working for a better client. And I don't think that, I think other organizations could strive to do this and should and probably do this where it makes sense in other contexts. But this is something to, I think, look up to, just in terms of the process we went through. So we got a play-by-play of having launched the case. We did, in fact, launch a case, and I'm going to speak a little bit about what we did. I'm confident that nobody on the call, other than me, has any interest in practicing as a patent lawyer, but perhaps you can be a little bit dangerous when discussing gene patents once I've finished the presentation. So first of all, what is a gene patent? Well, it's a monopoly. It's a 20-year monopoly that prevents anybody else from doing or practicing an invention. And what is an invention? It's something that is new, useful, and non-obvious. New in the sense that it's never, ever been publicly disclosed. Useful in the sense that it has some practical industrial use. And non-obvious in the sense that it's not something that any old scientist would have known to do. There's some spark of invention that was involved. And every patent, including every gene patent, has to be new, useful, and non-obvious. And if you think about a gene, and as we heard from Olga, for naturally occurring genes, and also from Julie, for naturally occurring genes, it's hard to say that a patent on the gene itself would be new, because this thing existed before. But for genetically modified genes, we might say, well, you created something new, and it might be a different analysis. We were looking at genes that already exist in humans. That was the very specific focus of our case. What do these patents look like? Well, there's two parts to the patents that we were particularly concerned about. One related to methods. And there's a lot of words on the screen, but what it boils down to is it's a patent that relates to the link between a gene and a disease, where the gene consists of that sequence, that genetic sequence of nucleotides, and the patent claims the ability to compare a person's nucleotides, their expression of the gene, or their embodiment of the gene, with a known healthy gene that was found in other patients a long time ago. It doesn't matter how it's done. It's just the act of comparing my gene to the patent gene, and then saying, well, and saying that any difference or reflects a potentially increased risk of disease. And anybody that heard Olga's presentation would know that that's a really complex exercise. You can't just say, okay, we linked the gene to the disease, now we're done. But that's what these patents purport to do. If we take a giant step back, the patent holder found some patients, figured out the patient's gene sequence using available technology, and then claimed ownership over the information in case somebody else wanted to find out that whether they too had risk of the disease. That's one part of the patent we had a problem with. The other part was claim of the gene itself. The patent covers the physical manifestation of the gene, here called an isolated nucleic acid coding for the sequence. The magic word was the word isolated. What the patent lawyers who got the patent said, they convinced patent offices that if they say that the gene has been isolated from its natural surroundings, then it's a different thing than what was naturally occurring and therefore is new and patentable. And that's something that patent offices had been willing to go along with until some decisions elsewhere in the world, and then our case as well. So what you hopefully would conclude is that patents and naturally occurring human genes are an awkward fit. The genes already exist. The methods of analyzing the genes are already known. And the patents privatize a fact of nature. And when I say privatize, it's somebody has a right to exclude others from using it. And until our case, even the most access-oriented patent licenses, such as for cystic fibrosis, which was a university licensing on fairly reasonable terms otherwise, still involve the payment of royalties, the monitoring of activities, and a barrier to running tests at hospitals for commercial purposes or for clinical purposes. So what were we trying to do with our case? Well, we had our ultimate goal. We weren't trying to prove to the world that genes are not patentable. That was something that was part of our case, but really we were looking for a practical result. We wanted to allow public hospitals and labs to comfortably offer genetic tests without having to think about and avoid patented genes, because it's expensive and it's deterrent. So was there a pathway for access? And there's several ways one could create a pathway: work around the patents, eliminate the patents, license the patents. And we were open to whatever would be a practical result, not knowing how things were going to necessarily play out. So what was the case about? Well, we asked a few questions. One, are these patents even eligible for protection? Can you patent a human gene because it's isolated? Can you patent the mere comparison of a gene sequences? Are these patents valid? Is it enough to just say, I found a gene, it seems to relate to a disease, now I get a patent? Is that enough work to get a patent, or do you have to do something more? We asked the question about, do these new tests infringe these old patents? Does next generation sequencing do the things that these patents were contemplating? And lastly, because of genetic testing by CHEO and other public hospitals and labs is publicly funded, is there a pathway in the Patent Act for these organizations to get special protection where they don't have to deal with patent holders? So those are the questions we asked. We did not want to have a slippery slope where our case was going to somehow lead to the conclusion that you can't patent drugs or genetic modifications or vaccines or proteins or gene therapy or laboratory instruments or tools. So we tried to be clear about that, and we tried not to vilify the patent holders because they were playing in a game that lots were playing in, and we did not want to single them out as somehow doing something sinister. We wanted to be clear that we were trying to get CHEO and others the ability to do what they should already have been able to be doing. So how did the case proceed? We filed the case in November 2014, took a long time. We had an obligation to file this motion where we sought cost immunity throughout the case, where we basically said, we asked the court, and there was some precedent for it, but hadn't been applied in our court. It was from the United Kingdom, and our Supreme Court had acknowledged that it was something available, but had never applied it, where we said, if you meet certain thresholds, you should be able to get a guarantee at the outset of a case that as long as you don't do anything abusive, you shouldn't have to pay the costs of the other side, even if you lose, because just resolving this issue is in the public interest. And we had lots of evidence from CHEO, from independent experts, from patient groups about to support us in that motion. And we filed the motion immediately when we filed our case. And what we found was you never know what will happen in litigation. We knew it was an experimental motion, and we drew a judge that was not terribly receptive to the motion and wanted us to take the case as far as we could without ruling on the motion, and also wanted us to talk settlement with the other party. So we filed the motion and let it ride, and we were able to cap our exposure for the earliest part of the case with board oversight. In April, we were hit with a bit of a curveball. The companies and organizations that own the patents transferred their interests to the company that was offering the long QT test. And that was too bad in some senses, because those earlier defendants may have been willing to do things that transgenomic was not. But it also focused our attention on one entity that was clearly making money off the patents. And we knew we had somebody willing to fight the case. And so it allowed us to move forward. And for this next 8 months or so, we did move forward. We produced our documents, and we had discovery in the case where we have examinations of witnesses scheduled for February of 2016. And it was that pressure, as is the case in all litigations, that actually caused Transgenomic to really ask themselves, do we really want to fight this? Is this worth it, going all the way to trial? And CHEO, we were doing it pro bono. We had everything lined up. We were going to trial. But what ended up happening was, although we didn't think a settlement would have been possible, after some discussions, what looked like an impasse became a breakthrough. And we saw that we actually had a pathway that we would be able to create through this settlement agreement that had been fully negotiated over a period of months. We finalized the settlement in March, and we announced it immediately. So what is this? So it's a public health access agreement. It reads right at the outset, just so it's clear what the parties were trying to do, that CHEO and Transgenomic enter into this agreement in the spirit of removing barriers that the long QT patents might form against not-for-profit long QT testing in Canada. And subject to terms and conditions, the long QT patents will not stand in the way of Canadians having access to their own genetic information and the benefits of such access for the detection, diagnosis, and treatment of disease when such genetic information is procured on a not-for-profit basis from CHEO or a third party, being any public institution that has been licensed by Transgenomic in furtherance of this agreement. So that's what we did. And why is the agreement important? Well, it's the first of its kind template for a royalty-free public license of genetic patent inventions. And it's not just that it's free. It's very easy to change the agreement and say it costs a certain number of dollars per use. It's the structure of the agreement that matters. Then the structure of the agreement doesn't change the way, in any which way, that a public hospital or a lab needs to conduct themselves in doing the genetic testing that they're already doing. There's no new costs. There's also no new obligations, no new monitoring. It's exactly what the hospital would already be doing. And the way we were able to do that was that the patentee was able to negotiate protections that ensure that if there is some profit or private sector use, and you can imagine some companies trying to come into the space, that they do not benefit from this license. And by structuring it this way, so that it's only publicly funded institutions that are licensed, we were able to then move to the federal and provincial governments and say this agreement can be a model for future access. It doesn't affect the private sector, other than the fact that the public sector is now better equipped. And it allows them to work within the Patent Act to develop policy that ensure that best practices in future situations are that gene patents won't pose a barrier. And there are mechanisms already in the Patent Act that enable that. And we've been having conversations with the province of Ontario for now and with the federal government about how to make that as streamlined as possible. And it will take time, but the agreement was the first step, and we're on to the next phase. So I'm going to stop there. I think it's been about 15 minutes, and I'm happy to answer any questions about this part of the presentation.
Thank you, everyone, for a great presentation. Really told a great story from beginning to end of giving us some background on the genetic testing in general, CHEO's journey through this, and Nathaniel, a great sort of insight into the legal side, which is not the comfort zone for many in the audience, being healthcare providers and clinicians. So, and a great story of CHEO's sort of leadership and really identifying their culture as the enabler, really engaging everyone from their board of trustees, as you'd really demonstrated, to their operations people side by side with their clinical experts. I mean, it was really a great story. The first question that came in, before we get to a question for you, Nathaniel, we'll go back to a question that came in when Dr. Riche was presenting, where you were talking about, where you mentioned the reluctance that, or would a physician be reluctant to report findings based on fear of a patent or actions related to a patent. The question came in was asking, are you aware of that ever happening where a patent owner has taken action against a physician for reporting on a patented gene in some way? Was it more of a fear of that happening, or are you aware of any cases where a physician has been confronted by a patent owner in a case like that?
Thank you for that question. That's an excellent question, and thank you for giving me an opportunity to clarify this. I cannot report something that I don't know about. So if the patent is preventing the laboratory from putting it on the report, as a physician, I'll be unaware of it, just like my patient. So the roadblock was more at the level of the laboratory being prevented from putting it on their report. And that was a discussion that we had with our laboratory when they had been explicitly told by the Ministry of Health that they could not put on their test menu genes on which there were patent. At that time, our laboratory was in the process of piloting that clinome, that test with the 5,000 genes, which has been available on a research basis, and our laboratory was validating this test at the time when we launched the lawsuit. And our colleagues in the molecular laboratory were quite nervous about whether they could report on genes that they had been explicitly prohibited by the Ministry of Health from putting on their clinical panels. So that interrogation stemmed from something that was really real and really part of our reality at the time.
And if I can just add to that, it's Olga, from a laboratory's perspective, and all the points that Dr. Riche has made are completely accurate, as the roadblock is at the laboratory side of things. And I am aware of laboratories who were in the United States, not in Canada, but I am aware of the circumstances when laboratories had a lawsuit landed at the door because they did launch a test for which gene has been patented.
Ah, okay. That's thank you for that information. So it wasn't just a fear or a gray area.
It's not a theoretical possibility. It's an actual concern, and this is why Ministry of Health, when they launch repatriation proposals, has specifically asked Canadian laboratories to look into these issues. So it was, as Dr. Graham has pointed out, it's something we had to look into before applying to the Ministry of Health to add this new tests to our license.
Okay, thank you very much for that. Nathaniel, you had talked about sort of the reasons that this case was started, and you sort of mentioned a bit about what were not part of the reasons. You weren't looking to change patent law. The question was that came in was, is the settlement that was achieved at the end of this, is this what you would consider the ideal outcome? Considering that it appears as though this applies only to this specific case, it's not changing the system broadly. It sets that template, as you said. But would you consider that? And you spoke a bit about, you know, it is a good situation in that it provides that template but while still allowing for the patenting in appropriate cases. So would you consider this to be the ideal outcome?
That's a good question. I don't think there is a perfect outcome. I could give you pros and cons of any outcome. So we say a few different potential outcomes. One would have been a slam dunk win of the litigation. One would have been a withdrawal on the part of the patent holder, and possibly a dedication of the patent to the public. One would be a settlement agreement, as we saw, and then there's also a version of a settlement that we would have contemplated in our heads before ever talking to them, which we had done. I think, so if we had won the case, then there still would have been the ability to work around the decision. Whatever the decision in the case was, patent lawyers would draft their patents around it. And what we've seen in other countries, so Australia, there was a successful litigation undermining or that invalidated parts of gene patents, and the net result has actually been to strengthen gene patents because the patent office has gone the other way and said, now we know you can patent all these other parts of the gene. And so it's had an unintended effect. In the US, there was a win, and then there's been years of lots more gene patent litigation trying to assess the contours of what's patentable and what's not. So we didn't want a Pyrrhic victory, and we knew that was a risk associated with even winning on every point in court. So I don't know if that would have been better, but it was something we would have liked too. It would have been a great result. If we had gotten a settlement where everybody has access, not just the public sector, that may have been better in some ways, but it would have been worse in others because there's no way that we would have been able to preserve the ability of labs to act as they already do as public sector labs. So I like ours better than that. And then in terms of a withdrawal, I think there's less policy force to a withdrawal of from the litigation which could have happened, than what we ended up getting, which was a fully negotiated solution that protects the patent holder's interests and also protects the public institution's interests. So I'm hopeful that by getting where we did, we can then say this actually does have some policy authority that policymakers should take seriously, and I think they are taking seriously. I don't know we would have been able to do that otherwise. We certainly wouldn't have been able to do it without launching the litigation.
All right, thank you very much.
That Nathaniel mentioned is the timeliness aspect. So what we cared most about was to protect access for our patient. And given the pace at which genomic discoveries are accelerating and the way those technologies are entering clinical practice, we really didn't have all of the time in the world. So this avenue allowed us to give access to our patients faster than a full litigation would likely have.
Yeah, I mean, so many things to consider here. I mean, as Nathaniel was talking about the unintended consequences of a different outcome, and as you're saying, Dr. Richer, about the timeliness of it. I mean, there's so many different things to consider, win or lose in this case. I mean, it's so interesting. Dr. Graham, one of the questions that came in was you had gone through a list of that long list of all those different, you mentioned the subcommittees or the working groups or whatever that you had to present to from the CHEO board and the University of Ottawa and that sort of thing. And you mentioned that you listed the tech transfer people and the other people that are interested in patenting scientific discoveries on behalf of the academic centers. Was there any pushback from particularly from those groups or any others to this, like recognizing that this may impede their ability to patent things that they may be working on? Did you feel any pushback from any of those groups?
That's a great question. I mean, I felt discomfort in some of my discussions with the technology transfer folks. I think, as Nathaniel highlighted, we were extremely careful to distinguish these kinds of gene patents from other very legitimate patents, and I think that we were successful in making that case. I would not say that all of the people with whom I spoke in that capacity were necessarily on side and agreed with what we were doing, but I think that my interactions with those individuals were largely in the context of trying to find out what patents the hospital and the research institute already held. And so, certainly there was a palpable sense of discomfort from some of them, but they were not in a position really to put up barricades, I don't think.
All right. So we are just about out of time, so I think we will wrap it up here. Dr. Graham, maybe we'll just look to you for maybe some, just one last question, and before we sort of give you an opportunity to sort of wrap this up, any closing comments or key messages you'd like to leave the audience with. But before you give us that, I'm curious as to what's next for CHEO in this regard. Has this incited a desire to sort of pursue more things in this area from the perspective of whether it's patents or other advocacy-related issues? Has this sort of initiated anything like that within the CHEO community?
Absolutely, I think it has. So we have the backing of our communications team, and we're in ongoing contact with Richard Gold, who I mentioned has an academic interest in this issue, and in fact Nathaniel and I plan to chat on the phone right after this about some initiatives that he's bringing forward. So for me, I think this was the beginning of a larger advocacy role that I'd like to play, not just with respect to this issue, but Dr. Richer, who chairs our Ethics and Public Policy Committee within the CCMG, is also working on with the support of the CCMG board, some issues around direct-to-consumer genetic testing and the regulation or lack thereof. So the short answer to your question is yes. I think we've got the. I think we're infected with an enthusiasm for advocacy issues that touch on our specialty, and that the success of this initiative, which I would attribute largely to our lawyers and to the environment in which we practice, has really given me anyway, the confidence to go forward with more initiatives.
All right, that's great to hear. I mean, we look forward to hearing about some of these interesting stories that I'm sure will be generated from that work. So anything you'd like to leave the audience with before we wrap up? Any closing comments or anything?
Well, I think that what helped us the most, in addition to an enthusiastic VP who really was visionary, is having that working relationship. So we have a triad model of leadership within our department that brings together our operations director, myself as the medical lead, and the head of our laboratory. The three of us meet regularly with our VP, and through our VP really have a direct line of communication to our executive team and CEO. So I think that CHEO is quite unique in that respect, a model that certainly works very well for us, and I'd encourage others to explore that.
All right. Well, thank you very much. And with that, I think we'll wrap this up. A fantastic presentation. So thank you to our full panel, Dr. Gail Graham, Dr. Olga Jarinova, Dr. Julie Richer, and Nathaniel Lipkus. A fantastic presentation. We did have a few technical issues today. I'm not sure if it's the first time for us for that sort of thing. So hopefully we'll be able to get the recording out to everyone and clean all that up so that it all sounds great when people get a chance to view that recording, which will be available in a couple of days. And just a reminder, we do our webinars every Wednesday at 11 a.m. Eastern registration time. We will be taking a bit of a hiatus after this one, but you can, during that hiatus, go and check on the Knowledge Exchange Network for any of our recordings that we've been doing over the last few years, if you are looking for something to fill your Wednesday mornings at 11. Next week, we will be hearing this is our last one until August 10th anyways. I'm not sure how many weeks that is. August 10th, we'll be coming back with Dr. Durhane Wong Ward, the Canadian Organization for Rare Disorders, and she's going to be talking about teens with rare diseases and helping them transition to adulthood. So not only will that be of interest to our folks interested in the rare diseases, but also our colleagues that are interested in transition to adult services and in that unique case of children and teens with rare disorders. So that's going to be a great session on August 10th. So hopefully you'll have a great summer, and thanks again for joining us today, and hopefully we'll see you back here in August when we return. Bye, everyone.